There is a moment that happens in many probate cases.
Usually after months of paperwork, delays, and legal conversations.
When someone finally says something very understandable.
Can't we just take what we have and end this?
That feeling is more common than people realize.
Probate can involve waiting, investigation, and careful documentation.
Episode 7.
Why probate cannot be ended early.
Understanding why the process must follow a structured closing sequence.
Families sometimes believe probate can end whenever everyone agrees to move on.
Especially if some assets have already been distributed.
But probate does not end simply because people are ready for it to end.
The probate process follows a defined legal structure.
And that structure exists to protect everyone involved.
Beneficiaries, creditors, and the estate itself.
Which means probate cannot simply stop when people become frustrated.
Even when families would strongly prefer that it did.
The law requires something more than agreement.
It requires that the estate administration be completed.
Which means the court must confirm that the estate has been properly handled.
And only then can the probate case actually close.
So the question becomes, what actually ends probate? What actually ends probate is not a conversation between family members.
It is a legal sequence that takes place inside the court record.
Before probate can close, the personal representative must complete several final steps.
Those steps form a closing sequence that courts expect to see in every probate case.
The first step is the final accounting.
This document shows the court what happened to every asset in the estate.
Next comes the plan of distribution.
This explains how the remaining assets will be distributed to the beneficiaries.
After that, the personal representative asks the court for discharge.
That request tells the court the estate administration is complete.
And finally, the court decides whether the probate case can close.
This final step is called the order of discharge.
Only after that order is entered is the probate administration finished.
Which means probate cannot simply end when people decide they are ready to move on.
The closing sequence must still take place.
Even if some assets have already been distributed.
Because receiving assets does not necessarily mean the estate is finished.
It may simply mean a partial distribution has occurred.
And partial distributions are very common during probate.
But they are not the same as the final distribution that closes the estate.
And understanding that difference explains a great deal about how probate actually works. One of the most common misunderstandings in probate involves distributions.
People sometimes assume that once they receive assets, the probate case must be finished.
But probate law distinguishes between two different kinds of distribution.
The first is partial distribution.
This happens when the personal representative releases some assets during the administration.
Even though the estate itself is still open.
The personal representative typically keeps funds in reserve.
Those reserves help cover remaining expenses, taxes, or unresolved issues.
The second type is final distribution.
This occurs after the final accounting has been reviewed.
And the court confirms that the administration is complete.
At that point, the remaining assets are distributed.
And the estate becomes ready for discharge.
So receiving assets does not necessarily mean probate is finished.
It may simply mean that a partial distribution has taken place.
And the administration continues until the court confirms everything has been completed.
Which is why probate sometimes continues even after beneficiaries receive property.
Because the final steps of the process still remain.
And those steps protect the accuracy of the estate administration.
Even when the process feels slower than families would like.
So what happens if families try to end probate before the process is finished?
Sometimes people believe they can simply accept the assets they have received and move on.
But probate law assumes something important.
That the administration must account for all estate assets before closing.
If significant questions about assets remain unresolved, the process usually continues.
Because the final accounting must reflect what actually happened to the estate property.
And sometimes those answers take time to obtain.
Financial institutions may require subpoenas or formal requests.
Historical transactions sometimes require careful review.
And digital assets or online accounts can introduce additional complexity.
Until those questions are resolved, the estate administration may continue.
Because closing probate too early can create new problems later.
For example, what happens if an additional asset is discovered?
Or if a financial record later reveals an important transaction?
Those situations sometimes require additional probate administration.
Which is why the closing process is designed to move carefully.
The goal is to resolve as many questions as possible before the case ends.
So the final distribution reflects a complete understanding of the estate.
Even if that patience can sometimes be difficult. In our next episode, we'll explore what happens when assets are discovered after probate appears to be finished.
And why probate law allows estates to be reopened in certain situations.
Because the discovery of new assets can change the final outcome of an estate.
And understanding that possibility is an important part of understanding probate.
We'll see you in the next episode.
Thanks for watching.